Welcome to the Docketing Excellence Webinar Series.
Welcome to the Docketing Excellence Webinar Series, which is sponsored by Black Hills IP and the SLW Institute. Black Hills IP is an accurate, efficient, and cost-effective U.S.-based IP docketing and paralegal service provider. The SLW Institute is an educational group created by the Schwegman Lundberg Wissner firm, which aims to provide insightful and useful information to the IP community. For this webinar series, we have pulled together docketing experts and managers from the Schwegman firm, Black Hills IP, and their respective clients and customers to educate on key docketing challenges and issues and share best practices on how to overcome them. The Docketing Excellence webinar series is free. To listen to one of our many past webinars or to register for future webinars, go to the Docketing Excellence Series tab of the Black Hills IP website, which is www.blackhillsip.com. And actually, I think that's now labeled our Educational Resources tab. The webinar that we are presenting today, I think, is the 21st docketing webinar that we've done, and it's the second docketing webinar in the Trademark series that we are currently focusing on. The topic today is specifically common U.S. and foreign trademark docketing mistakes and how to avoid them. We've allowed time for questions at the end of the webinar. The questions may be submitted using the Q&A button at the right-hand side of your browser window. You can submit a question at any time during the presentation, but the question will be held until the end when we go through them. Our presenters today are myself, Patty Giuliano, and Shelley Cape. I'm Ann McCracken, the president of Black Hills IP. I'm a patent attorney with 20 years experience in patent prosecution. I was a partner at the Schwegman firm for 10 years, and I was also a full-time law professor and directed the patent prosecution program at Franklin Pierce Law Center in Concord, New Hampshire for 5 years. Patty, please introduce yourself.
Yes, my name is Patty. As she mentioned, I have been with a trademark paralegal for about 20 years. I'm with the Schwegman firm, which is based in Minnesota, but I office here in San Antonio with my attorneys, Pam Huff and Christy Dent. I've been with Pam almost my entire 20 years doing trademark law. As I've mentioned in the past, I will be talking today about trademarks and docketing of trademarks and dealing with deadlines from a paralegal perspective. Shelley will be here to help us also from a docketing perspective, just getting a different view on how we handle some of the issues that arrive. I've spent most of my career using the PATSI database, and I'm now in FIP, and I think day by day I'm feeling a lot more proficient in FIP, but I'm still learning something every day, but I guess that's a good thing.
Great, thank you, Patty. Shelley, tell us about yourself.
Hi, I'm Shelley Cape. I am the Quality Control Manager at Black Hills IP. I have been in the IP field for a little over 40 years, doing a lot of work as a trademark secretary and a patent secretary early in my career. Since about 1995, I have been specifically geared on the docketing side, again with patents and trademarks, U.S. and foreign, in a variety of different roles. So it's kind of kept my skills awake and alive. And like Patty said, I've got a different perspective from her as a paralegal, and hopefully our two perspectives can answer any questions that may arise.
Great. Well, Patty and Shelley, thank you so much for being here today. Patty, I will start with you and let you just give a quick overview on what is a trademark.
Sure. This is a very basic, what is a trademark, and we went through this on our last webinar. So basically, generally speaking, the term trademark can be used to refer to both trademarks and service marks, but the term service mark is only used for marks associated with an actual service. For docketing purposes, there is no difference between a trademark and a service mark. An example of a trademark could be like Herbal Essence, which mark is used in association with hair care products, the goods. Other marks might be service marks and trademarks. For example, Starbucks. Starbucks has protection for its beverages, but they also have protection for their various retail services. Likewise, Uber has protection in association with goods and services as well. Conversely, a patent might protect the method Clairol uses for making their products or the algorithm that Uber uses to connect the drivers with its passengers. So this month we're talking about specific U.S. docketing actions that can be problematic. First, we've said it many times and will continue to stress the need for active status checks. After response is filed, after a publication opposition period expires, after you file a statement of use, always, always, always be sure there's an active status check, as it is the applicant's responsibility to monitor the flow of the application through registration. Docket actions that are after filing might be, among them would be a foreign filing priority date. The Paris Convention allows for filing in foreign countries claiming benefit to the home country filing date if that foreign application is filed within 6 months of the original filing date. Should note that not every new filing is eligible for the priority claim, even though most systems docket this date automatically. Generally speaking, if a mark has been registered anywhere for the same goods and or services, then a further priority claim is not allowed. However, if you're filing for different goods or services, then you may be able to take advantage of the priority claim. So when the priority claim is available, it has always been our practice to advise the client of the possibility of foreign filings when we send the confirmation of the U.S. filing. Sometimes clients don't read all the details in your emails, and they don't notice it. And even if they do notice it, they expect you as part of your customer service to send them a reminder that the date is coming up. So it's important that you have reminders set up so the date doesn't sneak up on you. I've found that typically 1 month notice is adequate, but depending on the client, more time may be needed. If your client is one that requires a lot of hand-holding, or if they need to confer with others in the company, then 2 months or more may be preferred. Also, we need to keep in mind the time difference. You always need to be sure to have the instructions at least 3 days in advance. Asian countries and Pan-Asian countries like Australia and New Zealand are very popular foreign filing options, and they're 14 plus hours ahead of us. So you need to contact your foreign associate at least a day prior to the actual date, as calculated in your U.S. docket. So there are many times when 3 days is just not enough. For example, most countries can supplement the filing subsequent to the filing date with your priority document and your power of attorney. But there are some jurisdictions that require corporate documents and powers of attorney prior to the filing. For example, in Middle Eastern countries, there are some countries that absolutely cannot file the application without the original documents. And of course, since it's the Middle East, they're going to require legalization, which could take weeks. China also has a requirement that you file a power of attorney with the application. It can be a copy of the power of attorney. So given the 3-day example, you would be scrambling around to get your client to sign a power of attorney, get it back from them, and get a copy emailed to the Chinese associate by the deadline. So these are just a couple of examples of why you want to start contacting your client well in advance of the deadline. And also, just as an aside, if your client is a foreign corporation or has offices worldwide, you may begin this 6-month priority timeline in reverse. If so, you may want to confirm that the country that they're claiming with priority to or from is a party to the Paris Convention, as the 6 months may calculated in reverse, in other words, from the foreign filing date to the U.S. However, if the company also has offices in the U.S., you will need to be prepared to offer a statement to the USPTO stating that the company has a real and effective office in the country of origin, or you could risk your priority claim. Now, Shelley and I have some docketing tips. First, you want to be sure that you are docketing the proper type of matter. The trademark priority deadline is 6 months, whereas if you inadvertently docketed this as a patent, you would get a 1-year deadline. You want, another tip is to be sure you secure instructions as soon as possible due to the time difference and potential documentation requirements. And another tip that I have is you might want to keep that 6-month deadline open until the final date, even if some filings have already been ordered. One example was recently we had a client requested only one filing because he didn't think he could afford all the countries he wanted. Well, we circled back with him as we got closer to the deadline and found out that his company had given him the budget to proceed with all of the countries that they felt they needed protection in. And also, some clients just like to test the water, so they might file in the US and the EU and China right off the bat. And then they don't want to request it. And so you may think they don't want any more foreign filings, but they're just kind of testing the waters to see how it happens, how things flow. And then closer to the deadline, they may decide if things are going well to go ahead and file in all their A or B countries as needed. So these are just some reasons why you might want to keep that date open until the end.
Well, thank you, Patty. So, Shelley, in your experience with docketing, what are some of the common mistakes that you see, particularly on foreign filing deadlines? That's such an important deadline.
I think one of the first things is what Patty brought up in her first docketing tip is if people are familiar with patents, they automatically assume that the foreign filing deadline is the same, that it's 1 year. It's not, it's 6 months for a trademark. So you need to make sure, as she said, that, in most systems, that automatically launching foreign filing deadlines when you add a filing date is going to launch correctly if you've got the correct file type. Basically a trademark and not a patent, depending on how your system works. Obviously, also you want to make sure that you enter the correct filing date, because that's also, even if it launches a 6-month date, but if it's off of a incorrect filing date, your foreign filing deadline is going to be incorrect. The other thing that Patty talked a little bit about was if the original case is filed in a foreign country. Some systems won't launch a foreign filing deadline in a foreign trademark application because the assumption is made they all come off of a US filing because that's where the software was written and everything. So if the first filing is, say, in Japan, in that Japanese case, you do need a 6-month foreign filing deadline to launch, and you just need to be aware that that's the first filing, and any foreign filings are going to come off of that Japanese case.
Okay. So let me stop you for a second there. So in order to avoid some of these errors, it sounds like making sure you have checklists or processes in place to make sure the record in your docketing system has the correct filing type.
Correct.
So that it launches a trademark 6-month foreign filing deadline instead of a patent 1-year foreign filing deadline. You also should make sure you've verified that the filing date is entered correctly, because if that's not entered correctly, you're not going to have 6 months calculate correctly. And then the one you just mentioned, make sure that date just launches, because if it is set up initially in a record, like a foreign record that might not have that built into the country law, you might not have that date launch at all. So those are some tips to avoid these problems, right?
Right.
Any other problems that could happen?
The only other thing that I can really think of, and again, Patty talked about this a little bit, was when do you complete a foreign filing deadline? Obviously, as in her example, if they had crossed off the foreign filing deadline when they did the original filings for their client would have never gotten the additional ones that they wanted. So I think it's really important that when you have instructions, especially if they come in early, before that 6-month deadline, say it's at 3 months, that just because something got filed, or we filed in the EU and in Australia, you don't automatically assume that's all the foreign filing that's going to happen and close that date out, because the client may want more and they have more time. So that's the one other area where you need to be very concerned about having complete and concise instructions. And maybe somebody that's really, maybe a paralegal crossing that date off instead of a docketer, because the paralegals generally are more in tune to the client and what the client is expecting.
Okay. So a couple process things here to prevent a incorrect removal of a foreign filing deadline. One would be, if the docketing department is responsible for closing out deadlines, making sure they only close out deadlines on very clear instructions that there will be no further filings, for example, and even having some designated language that the staff has to use when they give the docketing department instructions, so it's clear for them when to take that foreign filing deadline off. If it's not the foreign filing department or the docketing department that's responsible, if you, for example, allow your paralegals to complete deadlines on the docket, consider having them be the one responsible for that date, because they're the one in communication with the client, and there's not going to be any misinterpretations of instructions to complete dates. They know when the client's done and when they've completed the filings, right?
Right.
Okay,
Yes.
Good. That's good. All right, Patty, back to you.
Sure. So we have a couple of slides on docketing actions after an office action issues. You get 6 months to respond to an office action. However, if the issues are relatively straightforward, an examiner may issue a priority action. A priority action gives you 2 months to respond in exchange for an implied agreement with the examiner that the response will be reviewed quickly so the application can proceed to registration sooner. That said, you are not required to file your response within those 2 months. You need to be sure that your docket includes the 2-month deadline as well as the full 6-month deadline. If you only docket the 2-month deadline and the client doesn't get you the information by that date, well, you might think, well, we're covered because we really have 6 months. However, if that date, the 6-month date, is not docketed, you could find yourself in trouble. Another option, another thing that might happen after an office action is if you're unsuccessful in arguing your case before the examiner, a final office action might be issued. In this case, you have 6 months to file your response, which is now called a request for reconsideration, but you also have to file a notice of appeal by the 6-month deadline. And this gets tricky because you have to file those two by that deadline, but then you need to be sure that you docket your appeal brief, because it will be due 60 days after you file your notice of appeal, and the examiner's brief is then due another 60 days after that. And then we have the optional reply brief, the applicant's reply brief, and it is due within 20 days of the issue of the examiner's brief. So that is a really quick turnaround, and when it comes in, it needs to land on somebody's desk quickly for action or the decision to make if one is going to be filed. So some docketing tips we have. Be sure you always docket the full 6 months as well as the priority deadline. In our case, we often docket an early response deadline when we get a final office action. We do this because it's our cue to file our final round of arguments or amendments early, because if it's something that can be addressed and the examiner accepts the changes that we've made or the new arguments, we've saved our client the appeal fees. And that is always the goal, is to better serve the client. But it's also important to carefully docket the appeal brief deadline and the subsequent deadlines, as I said, in light of the really short response timeline for your reply brief if you decide to file one.
Okay.
And Shelley, what do you think?
I agree with almost everything you've said. Well, with everything you've said. When we're talking about, especially the request for reconsideration and the notice of appeal, it's really important to be aware of your system and how it works. Some systems will docket the request for reconsideration and the notice of appeal as a single docket entry. And if that happens and you file your request for reconsideration early, as Patty mentioned, you're technically not done because that notice of appeal still needs to be filed. So you've got one docket entry. If you close that out based on the filing of the request for reconsideration, you're going to miss that notice of appeal deadline. So that's one big mistake if your system only has the single docket entry. So you need to figure out how do you document in your system that that request for reconsideration did get filed and the notice of appeal is still outstanding. Obviously, for some systems where they have two docket entries, you can close out your request for reconsideration and your notice of appeal deadline will stay on the docket as its own single entry, and it's a little bit less problematic in that way. There's at least one system that I've worked in where the final response deadline is docketed as one entry called response to final office action.
And that was it?
And that was it. It doesn't say anything about a notice of appeal, doesn't say anything about a request for reconsideration. So if you're using a system like that, your users need to be really aware of what needs to be done. Your docket isn't telling them which documents need to be filed, and your docketers need to be aware of what documents coming in are actually going to relate to that response activity. Obviously, it's best if your response actually says that a notice of appeal is due, but in this case, it did not, and we had to be really careful about when we closed that date out. Did we get the right documents to respond to that?
So thinking about things from a process standpoint as far as docketing procedures, in an example like that where there is not a separate deadline for the notice of appeal, and you have filed the response to the final office action or the request for reconsideration, could you have like a checklist or something for the docketers to follow? Could you have some type of a documentation that would have them add a date when you got into that situation?
Absolutely. You know, obviously your organization is going to have certain procedures that they follow, and based on the system that you're using. And if that is one of the pieces of your system that there's only the one entry date, your process checklist documentation could all say that, okay, the request for reconsideration got filed, close that date out, but manually add that notice of appeal 6-month deadline. Opens up to a little bit more possibility of mistake to have someone manually adding that, but if that's how your system works, you can cover it by having it, well documented in your procedure.
And that would be calculated, if you're doing it manually, 6 months from the date of the final office action,
from
right?
the mailing date of the final office action, correct.
And
Kelly,
then,
I have a question.
Go ahead.
Do most systems automatically docket the appeal brief deadline when you close out the filing of the notice of appeal?
So the appeal brief deadline following filing of the notice of appeal, does it launch an appeal brief deadline? Probably.
Yes. Most, I can think of one or two that don't, but I think that's a programming issue, not a lack in the software, but just that you need to ask them to turn that on or something. But most systems that I've seen, yes, they will. Once you file your notice of appeal and close it out with the filing date, it will launch the appeal brief, which, as you noted before, Patty, again, if you're thinking patents versus trademarks, the appeal part here is very different time-wise than the patent is. The appeal brief is due 60 days from the filing of the notice of appeal, and there are no extensions, which we have on the patent side. So that could be a big mistake if depending on how, if your system doesn't automatically launch it, if it's tied to some kind of patent code or something. If you see an appeal brief in a trademark case launching with extensions, you've probably used an incorrect code or task or something, because there are no extensions available.
So that appeal brief due deadline needs to be a final non-extendable date
Right. And
or the 60-day date.
right. And it's 60 days. It's not 2 months.
Oh, good point.
Because, you know, there are some 2-month periods that are longer than 60 days.
Mm-hmm.
So again, we're used to months on the patent side,
Mm-hmm.
but that's not the way that it is on the trademark side. It's 60 days.
So docketing the appeal brief as an extendable date would be a mistake. Docketing an appeal brief as a 2-month date rather than a 60-day date could also be a mistake, and those
Correct.
are two common mistakes.
Correct. And then, you know, basically the same thing applies. Some systems will docket an expected date for the examiner's reply, some don't. That's obviously not something that one of our clients or customers needs to respond to. The following one, where the reply brief, which Patty said was due 20 days
Mm-hmm.
from that examiner's reply brief, again, it's a non-extendable deadline. So that needs to, a mistake could be thinking you can just get extensions like you can on the patent side. Patty mentioned you need to get it on someone's desk right away. So a lot of times in places where I've worked, we've got certain documents that are tagged as urgent. These need to be dealt with today. So you're working a little bit faster on some of those. And if you don't have some kind of code or specific guidelines, you can get really, there's the possibility of keying in something. It's unusual to key in 20 days.
Mm-hmm.
And a lot of systems, you have to do that manually. So you're counting on your fingers or you're counting on a calendar. Is it 20 days from today? Is it 20 days from the day that this mailed? The mail date, does that count as day one? You know, it can get,
Oh my gosh.
it can get a little frantic at times. So just, you know, take a deep breath, count 20 days, hope your system does it manually or automatically, so you don't have to do it manually.
One last thing before we move on to the next topic. Going back, Shelley, to the original example you gave about the notice of appeal deadline being a single entry in a docketing system along with the request for reconsideration. When you have that, obviously you wouldn't close that out until you got to the point where you were filing a notice of appeal or you knew you didn't need it. But how do you keep track in that type of the system of whether or not the request for reconsideration has been filed at that point?
At the point of the notice of appeal being due?
Well, at the point that you filed how do you know that you filed the request for reconsideration when you have a single date that says request for reconsideration / notice of appeal? One's filed, but the other isn't. Both dates stay on the docket.
Most docketing systems have a capacity for adding comments to an action.
Mm-hmm.
Foundation IP does, CPI does.
Mm-hmm.
You could note in those comments
mm-hmm.
that the request for reconsideration was filed on such and such a date.
Okay.
So that when the notice of appeal or the whole thing comes up on the docket, those comments are obviously displayed so you'd know at that point
okay.
that the request for reconsideration has already been filed. We're simply waiting to see what happens and for that 6-month date to determine if a notice of appeal needs to be filed.
Yeah, so then that would tell people why they were seeing it on the docket, whether
Right.
they were seeing it because the request for reconsideration was due, or if that was already filed, they'd see that in the comments and they were seeing it because the notice of appeal was due.
Right. You know, if your system doesn't have the capability of adding comments, another thing that I've seen work is you can sometimes change the task name. So you could take out request for reconsideration
mm-hmm.
so that it just showed up on the docket as notice of appeal.
Oh.
Now that's from years ago.
Yeah.
I don't know if there's any systems out there that still, I think most of them would allow that to happen.
Mm-hmm.
Not sure it's a smart thing to do,
right.
but it's a possibility of being able to do something so that you don't, for some reason, think you need to still file that request for reconsideration.
Sure. Well, from what you two have told me, appeals are not as common in the trademark space as they are in the patent practice. So these things are areas for common mistakes, partially because they're not done that much. Your docketing team doesn't deal with these particular scenarios that much either. So this is a good discussion. Patty, I'm going to turn it back to you.
Okay. When you file your response, you may include arguments against the side of a blocking prior pending application or registration. You may have to argue against a descriptiveness rejection, or you may need to submit amendments to your descriptions of goods and services. Another type of response to some concerns is to divide out the classes that are the subject of a rejection so the other classes can proceed to registration. A trademark divisional is not the same thing as a patent divisional. An example is we've had applications with numerous classes, and there were third-party registrations and prior pending applications blocking a couple of the classes. We divided out the classes that were good to go, and they were eventually approved and passed a registration, while the goods with issues stayed behind in the home or parent application until all the third-party issues could be resolved. The classes that are divided out into the new application are in now what is known as the child application, and the goods that stay behind will remain in the home or parent application. And just in a side note, you can also request to divide out goods and services when you file the notice of allowance, but that's not what we're talking about here, but I just wanted to make that comment while we were talking about request to divide. If you're expecting some of the goods or services to take a lot longer to be put into use than others. So we have some docketing tips here. The thing that I see a lot of people confused about is when you file a request to divide, you do not get a serial number immediately. Sometimes it takes 2 or 3 weeks because you'll get your, it usually comes in the form of an office action, and then it's a request to divide, and it's approving it, and it's giving you the new application number for the child application, the goods that are in use that are moving out of the parent application and going forward. All the dates in the child application will be the same as those in the parent. So they all carry over with the child application. So you need to be sure all deadlines and details travel with the record. And then you need to be sure to confirm the details of both applications. Shelley was giving a very good description of how she does that the other day, and I think that's probably the best way to do it. So you have all of your stacks in order and you know what is belongs in which application. But you also want to check the record when you receive the approval of the request to divide to be sure that the USPTO has checked all their boxes as well. We recently had a situation where the parent application was not updated properly. So we went to file our request for extension of time in the parent, and it still had all the classes of goods and services. Well, we didn't want to affirmatively delete any of the goods for fear that that might have some kind of repercussion on the child. Even though the child had registered, we were pretty sure everything was okay, but that's just one of those things you're kind of uncomfortable saying delete these goods when you're filing an extension request. We were able to, get back to the examiner and get back to the person who processed the request to divide, and they did update the record before we filed our extension request, but it was just a lot of unnecessary scrambling that if I had looked earlier and to see that they had not updated the USPTO record for the parent, it would have saved a lot of last minute scrambling. But lesson learned.
Okay, so Shelley, what kind of mistakes can happen here when you're dealing with divisional applications?
I think the most obvious is a failure to transfer any due dates from one application to the new application. A divisional means you have to set up a new record. You have to set up that child record. And any of the due dates that are still existing in the parent also apply to the child until you hear from the patent office or the trademark office differently. So typically, a file setup is a manual type of a thing in most systems. Some of them do it pulling priority information and stuff into the new cases, and some of them you can copy a case and then make the changes. But getting those due dates to make sure that they're right is probably the biggest thing. Most of the time, everything else isn't going to make that big of a difference. It's just those due dates getting into the child so that they match what's in the parent.
And in most systems, those have to be manually added to
Most
the new
systems, yes.
record for the division.
Yes. The other thing that I can think of that could be a mistake in this situation is because the classes are changing. That's one of the things that you need to make sure you do. It doesn't affect due dates, but it affects the bibliographic data in your system, which is one of the reasons for the system, is to have proper bibliographic data. So another error or mistake would be not properly updating, as Patty was talking about, the USPTO didn't, but if you don't do it in your system either, you can have incorrect classes and goods and services in the various cases. So you want to make sure you get those right. And I know especially when I first started working with these, it's confusing because you're getting a new serial number. The filing dates stay the same from the parent to the child, but you're getting this new serial number. You see a request to divide and you don't have that serial number yet, so you kind of think, I don't have all the information I need. I know it's the age of computers and doing things from screen to screen. This is one of those things where, and this is what Patty was talking about before, about kind of how I handle this. Mm-hmm. I will print out the request to divide or the notice of acceptance from the trademark office, and either have two copies of it, so I've got one on each side of my computer, so I know one is for one case and one is for the other case, or I'll just highlight or cross off. But as I add the goods for serial number XYZ, I'm noting it on my printed document, and then as I'm putting them on for the one for serial number ABC, I'm making sure that matches what's on my docket. I still have to do it manually like that, just to confirm to myself that I'm getting things in the right places.
Yeah. Well, and even though that's not a deadly mistake to have a error in the classes listed in the record in the docketing system, it leaves bad data in your assets in their portfolio if they're a corporation, or to track their clients' matters, and often are pulling reports on that data. So that's another one that's a common mistake, and it's important to have that data be correct because it's very relied on, even though it's not relied on for a due date. It's relied on for a lot of other reasons.
Correct.
Okay, Patty, let's go back to you.
Sure. There are docketing actions after you get your notice of allowance. So if you file your application based upon an intent to use, then you have to file a statement of use to prove up your use before you can get a certificate of registration. The timeline for filing the statement of use starts at the issue date of the notice of allowance. You're given 36 months from the notice of allowance to prove up your use, but you must file extensions every 6 months along the way. They are obviously 5 6-month extensions available. When you file your statement of use with specimens, if you have any doubt about the sufficiency of your specimen, you may choose to file what is known as a conditional extension of time along with your statement of use. A conditional extension gives you a little extra time to put the mark into use if your specimen's not accepted. Without the extension, the conditional extension, if your specimen is refused, you will have to provide a substitute specimen that was in use at least as early as the date you filed the original application. The original specimen. So docketing for these can be really tricky. For example, if you file your statement of use 3 months early, but you're still a little unsure if it will be accepted, you may not want to file your conditional extension at that point because you have to pay the $150, $125 fee for the conditional extension. So you'll wait until closer to the deadline before you file that conditional extension to see if your specimen's been accepted. But this can be really tricky, like I said, when you have a docket system that has that treats the statement of use and the extension as one docket entry. This is, again, what we were talking about earlier, when you have one docket entry that's really for two separate and distinct filings. So some of the docketing tips here are to keep that docket deadline open if you file the statement of use before the deadline, so you can file a conditional extension if needed. And always be sure that you look at how you're docketing the statement of use, if the statement of use and the extension are docketed as one docket item.
So it does sound tricky. Shelley, what kind of mistakes have you seen around statements of use and extensions of time?
I think one of the most common is what Patty had just talked about. Some docketing systems do treat the statement of use and extension of time as a single docket entry. And in the case of filing your statement of use, and unless it's really well communicated to your docketing department, they're going to assume that you've met that deadline and they're going to close it out with a statement of use filed. So you need, if you think you're going to need to file that conditional extension of time, you need to really let your docketing department know that that extension of time date needs to stay open. If the system has two different entries, one for the statement of use and one for the extension of time, it's easy to complete your statement of use date and leave your extension open. But it's not so easy if your system treats them as one entry. So again, we're looking at like what we were doing for the request for reconsideration and the notice of appeal, ways of documenting what's been done, what hasn't been done, and clear and concise instructions. The other thing that I've seen is, for whatever reason, when the extension is filed, statement of use, and that stuff is documented, the next 6-month date doesn't launch. Some systems, most systems that I've seen, will docket the next 6-month date. There are some systems out there that launch all 36 months worth of dates. So you don't have to worry about the next date, not the next extension date not being on the docket. But that's another thing that I've seen, is that for some reason there's a glitch in the system. It wasn't closed out with the right kind of notation, something like that. The next date doesn't launch. So you really need to have whatever checklists or procedures you've got in place that someone is checking to make sure that when you close that out, the next date did launch and you've got that date out there.
Okay. So failure to launch one of these subsequent actions can be a mistake.
Yes.
And whether, again, thinking about it from a process standpoint, if you can have checklists for your docketers or your docketing manual, something that says when one of these is closed out, make sure that you relaunch it if the statement of use has not been filed yet.
Correct.
Right? Okay, good. All right, well, let's keep going.
Okay.
I'm going to give back to Patty.
Go ahead. Okay,
nope,
maintaining foreign registrations. Okay. So maintaining foreign registrations in other countries is pretty straightforward, but there are a few exceptions to keep in mind. For example, some countries give you the opportunity to pay rehabilitation fees to protect a mark if it's not in use. Honduras is a small but representative country for this process. Along the same lines, in some South African countries, it is strongly suggested that you publish a declaration of intent to alert the public to your intention to protect the mark. Failure to do those publications can put your mark at risk. There are also countries besides the U.S. that require periodic declarations of use. For example, the Philippines, you have to file your declaration of use within 3 years of registration, or the registration will lapse. So there are some unusual foreign deadlines that will pop up, and hopefully your docketing system is familiar with, well-versed in the country law that you're entering the information for. As for renewal fees, they vary widely, and the process varies even wider. In many countries, you just need to contact your foreign associate, confirm the details and the current ownership, and ask them to file a renewal application. They file the documentation, get a certificate of renewal the next day or next month, or sometimes 2 or 3 years from now, but it's all just fairly straightforward after it gets filed. There's other countries like Mexico, for example, that you have to affirmatively declare that the mark is still in use. Yet others, like the Middle East, make it even a little bit harder for you, because in some of these countries, you need a new legalized power of attorney, and they want the original certificate of registration for endorsement. I think many of the countries have stopped this practice. I think Kuwait may be the only one still doing that. But this brings us back to the timeline of working with your client in adequate time to get the necessary documentation in time to get it where it needs to be by the deadline. I also want to point out that protecting and maintaining registrations in the EU is completely different from the patent world. The EU registration, which is formerly the CTM, is a singular registration that does not require validation or confirmation at the country level. It is a true one-stop shop. You file one application and maintain one registration, and it covers all the countries in the EU. Of course, there's the Brexit issues to consider, but that's a whole nother webinar all to itself. Some of the docketing tips we might want to consider here is watch for the unique country requirements and give yourself enough time to gather the information. The other thing that I would add here is that you'll want to make some kind of notation in your docket. I'm always reluctant to clear out my renewal item on my docket until I've actually got an email from my foreign associate that said it has been filed, or I get the filing receipt. I just sending them the information and they say we've got it. I'm just not comfortable clearing out the docket item at that point. And so you need to make sure you have adequate notes in there so somebody else doesn't go back in and say, oh my gosh, you missed this deadline, or oh my goodness, and they contact the foreign associate in your place or something, just to be sure that you've got a note in there that you've sent the instructions have been acknowledged, now we're just waiting for confirmation of filing.
All right, Shelley, anything else to add on the foreign registrations and particularly maintaining them?
There's not really a lot, and I know that future webinars are going to talk more about the foreign process and probably more specifics. I think the one thing that I would say is renewals are generally due 10 years. Some countries are different, Canada being one of them, but some are due 10 years from filing, some are due 10 years from registration, and hopefully your system has country law in it that knows how to launch those dates, but I really would recommend that you rely on your foreign agents for those dates and confirm that whatever date they're giving you matches what's in your system, and especially if it brings back a date that doesn't align with either one of those registration or filing dates, that you go back to your foreign agent and say, this doesn't sound right, or some nice way of saying, we're confused, what date is it really? Along
those lines, Shelley, I would say that I think it's Saudi Arabia that still, I'm pretty sure they still use the lunar calendar, or is it it's the lunar calendar.
Oh my gosh.
And so you have to rely on the date they give you in your correspondence, because obviously very few document systems are going to be able to pick that up.
Okay. So, the biggest way that mistakes could be made is if your system launches a date automatically and it doesn't match what your agent is saying, you need to follow up with your agent to confirm what they know what the date really is. And so not picking up on that discrepancy would probably be, and having an incorrect date docketed would probably be the biggest thing at this point. Most used systems do have the country law that will put stuff in if you've got everything added correctly. So, we can obviously follow up on some of this in the foreign webinars that we do, but I would say that's the biggest thing, is those foreign filing renewal dates.
Well, and that's a good point. If the country law in your system is calculating different than what the agent tells you, contact the agent. And And another point here that I'd like to make is, remember, the U.S. attorney's docket is essentially a secondary docket or almost a backup docket in this scenario. Your foreign associate is the primary one responsible for the deadlines. They're carrying those dates on their docket. You're carrying it on your docket either for informational purposes or because you need to be providing instructions, but you are the secondary docket. And it really is your agent's responsibility. And so if something looks odd, contact them because they have it and they know it.
Sure.
All right, Patty?
Sure. I just have a couple of last slides here that are kind of just like a primer for some things we're going to be talking about in future webinars that are going to kind of delve further, as Shelley was saying, into some foreign issues. But as most people know, you don't need, aside from Canada and a couple other countries, use is generally not required in most foreign jurisdictions to get a registration. However, the registration can become vulnerable to non-use if it is not put into use by a specific period of time. This is where the soft use deadlines or the proof of use deadlines come into play. Soft use deadlines or the proof of use, these can be very important as they alert the client to the potential for non-use cancellation actions. The protected period of non-use can be 3 years or 5 years, and it varies on whether the time period starts at the filing date or the registration date. It is an important mark, if it is a really important mark for the client, yet they're still trying to finalize contracts with local distributors, or if they're still working on their market strategy for that region, they may want to consider filing a fresh application to kind of restart that protected period. The downside is that in some countries, you will have to expressly abandon the earlier registration, in which case you lose your priority date or the earlier filing date. But if third-party actions are concerned, this might be the best way to maintain protection. Another option is to file a new fresh application with goods that are slightly different or with a design element or something else that differentiates itself from the earlier filed application. But there's so many issues to consider before taking this action and filing this fresh application. We'll go into that in further detail in a future webinar. A couple of other miscellaneous items that I just wanted to touch on is U.S. watch notices. You get these from, most people get these from like a third-party service. The attorney reviews them, and the question is, how do you get it into the docket? Because there's usually so many. We see volumes and volumes of these watch notices come through. I guess because of the way they're set up, you just get so many. And you just have to count on the attorney to give you that information that, I'm going to follow up with the client, make sure that this deadline, this opposition deadline is in the docket. Another kind of watch notice is the ones you get from your foreign associates, or maybe not even your foreign associates, some other random firm, which we see a lot. Is people trying to get your business, I guess, is they'll see that there's a mark that's been published that's similar to a mark that your client has filed. Maybe not even in that country, maybe in other countries, but they're bringing them to your attention. Either way, I always docket those deadlines when they come in because it's easy enough to remove if the decision is made not to oppose. However, missing that deadline could really compromise the client's rights. And we've also the question's been raised about when do you open that new opposition matter. For me, it's really not a black and white situation because part of it depends on the client, how they like to manage their budget. It's if all of their prosecution is in one budget and all of their infringement action is in another budget. And part of it depends on the mark being reviewed. I mean, it could be something that we're pretty sure nothing's going to happen. But typically, we don't open a new opposition matter or a cancellation matter for that matter until there's like a formal investigation going on and expenses being incurred or deadlines that need to be monitored closer. In reviewing the watch notice and providing opinion, we usually wait until we hear back from the client. And just lastly, I would just like to just touch briefly on docketing for the maintenance actions in the U.S. and in foreign. We talked about that a little bit, but I wanted to remind you that there's usually an extension of time to file, but most require an additional fee. Similarly, in the U.S., the affidavits of use and the renewal applications have a grace period, but you can get yourself into trouble if you go too far into your grace period. Sometimes it can't be helped because there's having trouble getting specimens from the client, but you're only given until the end of that grace period to remedy any problems that may occur. So if you file your affidavit of use or your renewal application a day before the end of the grace period and your specimens are not accepted, then you're just you're out of luck and you're going to have to file a fresh application. But again, these are all things we'll delve into much further in future webinars, and I look forward to sharing some of our thoughts with you then.
Well, thank you, Patty. Shelley, any general comments on this list, or wait till we get into them in more detail?
I think wait till we get into them in more detail.
Okay. All right, we'll take a few questions before we wrap up. So I just want to remind people that you can submit questions with the question bar on the right-hand side of your browser window. If you have questions generally about Black Hills IP services or processes, please contact Jim Brophy, our Vice President of Sales, and his contact information is posted there. We will post the slides and an audio recording of today's program on our website. Again, that's blackhillsip.com, and we have an Educational Resources tab, and then under that tab there's a Docketing Excellence Series menu, and these slides will be posted. Give us a couple of days to get them processed and up on the website. So let's see what we have for questions. Just a second here. All right, so this is related to the discussion of divisional applications. What are examples of due dates that should carry to the child application when the case is divided? Are you referring to the PTO response dates? Shelley, you were talking about moving the dates to the child, so I'll let you answer that.
Yes, basically any date that's in the parent. Most of the time, a request to divide is going to be filed along with a response of some kind. So that parent probably is going to have a status action in it, and if it's still within the 6-month, the foreign filing deadline. So those are the deadlines that should go. It could be that the parent has been allowed and we're working on extensions of time and statement of use. So in that case, it would be those dates that should go over. So the PTO response dates. So any status check if it's there.
Basically, any open patent office dates that are there need to be transferred over to the child record when you're adding the docketing to the child record. All right, this one has to do with extensions of time and statements of use, which are tricky. If an extension of time is filed concurrently with the statement of use, but then an office action is issued and provides a 6-month response deadline, is it required to pay the next extension of time prior to the response of the office action? That sounds tricky. Patty, have you had that happen before?
We've had that happen. I do not believe you have to file the extensions of time if an office action has issued. But I would have to double check that. I would have to double check that.
Yeah, I agree. I would double check it, but I do agree with that as well in the way that we have previously docketed things and looked at things. When you receive that final office act, or when you receive that office action, it's kind of saying, we've got these documents, we're kind of accepting them. The rest of the process is finished at this point. Let's just take it from here.
Okay.
Well, and the other thing I would add to that is you cannot file an extension of time after, this is going to be tricky to explain. You cannot, once you file your statement of use and you reach that deadline, after that 6-month deadline, you could file a conditional extension, like I was explaining in my example, that your specimen wasn't accepted, so you're going to file a conditional extension at that point, but you cannot file another extension after that.
Oh, okay. All right, let's go on. This is a good one. In our system, all 36 months are docketed automatically. So I assume this person is talking about once you get a notice of allowance. All 36 months are docketed automatically, but it's unclear if the next extension of time would have to be paid if there is a pending office action. Is that the same question as the one we just answered, just stated in a different way?
I think that's what I was thinking.
I think so.
Yeah, so apparently this is a tricky docketing scenario that does come up, and this is a great question. I love this one. Patty, this is probably for you. How hard or easy is it to revive a trademark application?
The biggest issue with reviving an application is you have to be able to declare that it was inadvertent. If it was truly inadvertent and you filed your declaration that you missed the deadline due to a clerical error or a docketing error and it was completely inadvertent, I've never seen anyone have a problem with those. But I think it's almost like more of a moral issue. Because the client will say, we don't want to do anything, let it go. And then they come back and say, no, we changed our mind. Can you revive it? Well, no, because we can't file the declaration saying it was inadvertent. We affirmatively let the deadline go.
So can you refile the application if you can't revive it?
Oh, sure.
Or is that, okay. So, and that's a major difference in the, oh, go ahead, I'm sorry.
No, I mean that you just lose all the priority in your filing date and all the other, you have to start over.
Right. Right. And so if the person who asked this question is more experienced in patent docketing, the revival is a very important issue. And not to say it's not in trademarks, but there is a little bit of a difference in that in the trademark world, you can at least refile. As Patty said, you lose your priorities, but you can at least refile in some situations where in the patent world you would have loss of rights. You agree with that, Shelley?
Yeah.
Okay. All right. What, if any, countries require you to keep the original certificate of registration? Do you know any examples of that, Patty?
The only ones I have seen that ask us to produce the original certificates of registration at this point are all Middle Eastern countries, and many of them, Turkey used to be one of them, and they don't have that requirement anymore. I'm pretty sure that at this moment it could be that Kuwait is the only one, but there could be others, but that's the biggest one that keeps coming up on my radar, is to make sure I have those Kuwaiti ones handy.
Okay. Is this the same question again? If there is a statement of use required, the trademark application has been accepted, so there should not be, oh, this is a comment, so there should not be an office action that would need to be responded to. Is that correct? So how do you get into the scenario where you have a statement of use required, but there's an office action?
If you file
an office action could issue rejecting your specimen.
Yeah, on your statement of use, if you didn't, if something wasn't right with your statement of use, you would get an office action.
So that's a common example of where this would come up, and that's the two previous questions that we had about this scenario. That's one way it could come up, is they reject your specimen.
Mm-hmm.
Okay. All right. Do you know of a good website other than WIPO to search foreign trademark registrations?
Oh,
currently, I've been doing searches for particular countries to see if they have a site. Any practice tips that you guys have, favorite places to go, websites to use to search foreign trademark registrations?
I look for the country trademarks.
To the individual country's site?
Yeah.
How about you, Patty?
I cheat. We have a subscription through Clarivate, which is Thomson, Sages, and to me they're kind of the gold standard in trademark searching, and they have like over 100 databases that we can look at. There's some that I can still get into, Japan and Australia, New Zealand, the EU, most of the EU countries, you can get into their websites online. But I often just go back to my, I'm not doing a commercial, but that's where I go back to.
No, but so that's a fee. That's a subscription service. There's a fee for it. It's a commercial service. Yes. But if you don't use a commercial service, there are a number of countries that have a searchable trademark website that you can go to.
And typically, trademarks are more searchable and available than patents are because they don't have the confidentiality stuff around them that patents do.
True. And here's a comment from one of the listeners. TM View is a suggestion, and I have not heard of this one. ASEAN View for free international searching.
Okay.
So those are ones to check out.
If I could follow up on a question that came up a few minutes ago, if the listeners would look at TMAP section 1108.03. That deals with only one extension request may be filed with or after a statement of use. So you might look at that section in the TMEP to get your answer, to confirm the answer that we were talking about earlier.
1108.03 was the section on that, right? Okay.
Yes.
And this ASEAN View is an Asian version of TM View, is the comment. So those are two good ones to go check out. We've gone over time, but let's just take one last question in here. If an office action would issue to reject a specimen, so going off that last question, and thus restart the clock to file the statement of use, why would you need to file a provisional extension of time request with the statement of use? Do you need me to read that again?
No, I think I understand what they're asking because this is something that comes up a lot. If you file a statement of use, Pam and I, my attorney and I have discussed this at length. If you file your statement of use without a conditional extension and your specimen is rejected, you can file, it's rejected and you have to file a substitute specimen. You have to file a specimen that was in use at least as early as the earlier specimen that you tried to submit that didn't work. So you have to find something basically that's already in use. If you file that conditional extension, that gives you additional time to put the mark into use. So your specimen does not have to be something that was already in use. Your client can put it into use, into proper use, and submit a substitute specimen in that doesn't go back that far. So it kind of gives you a little more time to put your mark into use if it's not accepted.
Okay, good. Well, we will move on. We've gone a little longer than we typically do, but these were some really good questions, so I wanted to make sure we went through as many of them as we could. Last thing, I just would like to point out that the next webinar for the Docketing Excellence Series will be on options and best practices for docketing Madrid and foreign convention trademark filings. This is in a month. It's on March 7th at 1 p.m. Central Time. So Patty and Shelley, thank you so much for sharing your experience on the program today and talking about the common mistakes. Hopefully that will help the listeners. And we hope that everyone will join us for this upcoming webinar on the 7th of March and for future webinars in the Docketing Excellence Series. And thank you again, everyone, for listening to our program today. Thank you.